Doug Weinstein filed what could be the end of the young thug RICO trial. He filed Diamante Kendrick's emergency petition for writ of mandamus, a stay of proceedings, and he filed it to the Georgia Supreme Court. Welcome to the show. Now, what is a writ of mandamus? It is a pleading to a higher court or higher judge to intervene in what is believed to be a government overstepping. As in this case, it is the Georgia Supreme Court, because they can't file it into the Fulton County Superior Court, because Judge Glanville is the chief judge. So there is nobody in Fulton County Supreme Court that can handle this. So they go one step above. And the Georgia Appeals Court has already said the underlying issue here is a murder case. So they punted it up to the Georgia Supreme Court, and now Doug Weinstein and his colleagues have filed to the Georgia Supreme Court. Let's get through it. This is in the Supreme Court, State of Georgia. Diamante Kendrick, petitioner, versus Chief Judge Glanville, respondent. Diamante Kendrick's emergency petition for writ of mandamus and stay of proceedings. Filed by Douglas S. Weinstein, EJABT, the ABT law firm, Katie H. Hingerty, and the Hingerty law firm. Attorneys for petitioner Diamante Kendrick. Table of contents. This is, jurisdiction, relief sought, issues presented, statements of fact, procedural history, the secret ex parte proceeding, events in court about the time of the secret ex parte proceeding, and so on and so on and so on. We will not go through the entire 83 pages because there's a good deal of, here are the case law, and it is extensive. Here are the state statutes, also rules of conduct, constitutional provisions, and here we go. Comes now Diamante Kendrick, petitioner, by and through his undersigned counsels, and brings this emergency petition for writs of mandamus and a stay of proceedings, showing as follows. Jurisdiction and explanation of emergency nature of petition. This emergency petition concerns allegations of serious breaches of the Georgia Code of Judicial Conduct that violate petitioner's state and federal constitutional rights. This petition relates to conduct of Chief Judge Glanville and not to any rulings or orders of the judge. This here is because Judge Glanville, in his decisions to deny motions of recusal of himself, always refers to his rulings. Judge Glanville is trying to avoid accountability and responsibility by saying, you can't do this because of my rulings. It doesn't matter. It has nothing to do with your rulings or your orders. It is your conduct. This court, as in the Georgia Supreme Court, has jurisdiction over this matter under Georgia Constitution, Article 6. These. In the case at bar, original relief in the form of motion for recusal have been filed and denied 3 times by 3 respective movements. Likewise, Glanville has denied the movements' respective requests for a certificate of immediate review 3 times. Yeah, in order for another person or another judge to take a look at this, they need a certificate for immediate review. Judge Glanville have punted this to the end of the trial, after the trial is conducted, which we know is a year and a half, maybe even 2 years into the future. And that is ridiculous. Because if he punts it to the appeals court, then Judge Glanville knows this will, first of all, take a lot of time. And second, the cost of that appeal is enormous. We are talking about hundreds and hundreds of thousands of dollars for the transcripts alone. Let me give you an example. After 21 days of trial in the Zachariah Anderson case, now it is, they will soon be filing for appeal. They had to pay $16,000 for 21 days. $16,000. And that is nowhere near, because we are at day 95 in this trial. And that does not take into account the hearing days. That does not take into account what happened outside of the camera view. It doesn't take into account all the videos, all the photos. I mean, I think, or I believe, that we are actually at around day 120, 140, something like that. But technically we are at day 95, and we are nowhere near close of the end of the trial. So the cost for the transcripts alone to get this to an appeals court, it's staggering. Hundreds and hundreds of thousands of dollars, if not on the region of over $1 million for the transcript alone. Glanville, as chief judge, has obstructed defense counsel's attempts to have a disinterested party review the numerous allegations contained in at least 4 affidavits which allege judicial misconduct and unfair proceedings. The disinterested party is another judge who is presumed to be neutral and look at the facts and the basis alone. These affidavits, if true, would constitute serious violations of the Code of Judicial Ethics, citing a lack of evidentiary foundation caused by Glanville's own recalcitrance. What? In refusing to provide a transcript of a secret ex parte proceeding, Glanville has hindered defense counsel's ability to effectively pursue relief by claiming judicial privilege while denying certificates of immediate review. Yeah, Judge Glanville refuses to release the entire transcript of that ex parte meeting. In court, he stated he would release only what he claims does not fall under privilege. Here's the thing. There were 14 people in that ex parte meeting. There is no privilege to attach. Every single word uttered in that ex parte meeting should be in that transcript and released to the defense immediately. But we know Judge Glanville refuses. Assuming this court would not get the opportunity to review the decisions on the multiple motions to recuse unless or until the underlying case was concluded, Glanville continues to hide behind a purported standard that his actions would be reviewed in hindsight for abuse of discretion. Glanville's obstruction of defendants' rights to a fair and impartial trial has risen to a level that defense counsel now believes all attempts to obtain relief in the Superior Court of Fulton County will be ineffective. 3 motions for recusal have been filed and denied, and 2 writs of mandamus are already attached to the instant case, which were filed and pending for more than 1 year. Here is the footnote. A petition for writ of mandamus in order to return seized property, in this case related to property seized during the arrest of Mr. Williams, was filed by claimants Raffaello and Company Inc. on July 24th, 2023. It outlines lack of actions by Chief Judge Glanville over the course of time dating back to June 17th, 2022. The petition for this writ has yet to be heard by Chief Judge Glanville, and claimant has not agreed to any delay in the hearing of its petition. In the meantime, claimant is without over $1 million in the property loaned to Mr. Williams for his performances. You might wonder, what is that? Well, that is civil forfeiture of things that was in Mr. Williams' house, as in jewelry that was loaned to him by this company. This company wants it back. Chief Judge Glanville won't even hear. He doesn't care. This company is out $1 million worth of jewelry. And Judge Glanville won't even entertain the thought that the civil forfeiture done by the prosecution and the police might have been illegal. He won't even entertain it. It's appalling. Therefore, any effort to file a writ of mandamus in Fulton County that would be heard by Chief Judge Glanville would result in frustration and lack of action. Glanville's court is where writs go to die. As the present petition for writ of mandamus would go to Glanville if filed in Fulton County Superior Court, petitioner has no option other than for the Georgia Supreme Court to exercise its discretion and consider defendant's claims. A secret ex parte proceeding was held on June 10, 2024. In attendance were Glanville, Kenneth Copeland, prosecutors Love and Hilton, investigators from the Fulton County DA's office, and members of the Fulton County Sheriff's Office. As a result of the proceeding, petitioner requested that the presiding judge, Glanville, recuse himself from petitioner's trial for, among other counts, count 2, murder, blah, 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 blah. Despite proceeding all requirements of Uniform Superior Court Rule 25, the motion for recusal was summarily denied without following the required procedure. Glanville denied the request for a certificate of immediate review. A formal order denying the motion was entered on June 14th, 2 days after the motion for recusal was filed. As Chief Judge of the Fulton County Superior Court, Glanville holds a unique position within the county which carries a significant amount of weight and power among his fellow county judges. Glanville has repeatedly refused to issue a certificate of immediate review that would permit the Georgia Court of Appeals to review his decision on the recusal motion. Therefore, invoking the original jurisdiction of this court to issue writs is petitioner's only recourse. If not considered by this honorable court, the still incarcerated defendant would be forced to wait for at least another year or more of trial before seeking appellate review. The appellate procedure in this case at bar will be extremely lengthy and cumbersome, with more than a year's worth of transcript to review. Yeah, they not only need the transcript to file, the appeals court needs to review it as well. Could you imagine that? The appeals court, ka-chunk, here's a room full of documents. terabytes of the terabytes of the terabytes of transcripts alone. Emergency relief is requested because the witness that was coerced by Glanville is presently on the witness stand. Absent emergency relief from this court in some form, Glanville will control the scope and substance of undersigned counsel's cross-examination of Copeland. Anticipated areas of cross-examination include Brady material that counsel believes was disclosed at the proceeding but not provided to counsel as required by law, as well as the coercive joint effort of the bench and state. Given the conduct during the ex parte proceeding, at least an appearance of impropriety, if not actual impropriety, casts a pall over any ruling that Glanville may make during counsel's cross-examination of Copeland. Relief sought. As Glanville has found petitioner's motion for recusal to have been filed and presented in a timely fashion, the Weinstein affidavit to be legally sufficient, and the affidavit containing facts that, if proven, would warrant recusal, petitioner requests this court grant a writ directing Glanville to adhere to Rule 25.3 and thus assign the motion for recusal for hearing before an unbiased judge. Petitioner further asks this court that proceedings in the trial in this number be stayed pending the resolution of the motion for recusal. As in, halt everything until this is heard by another judge and the Georgia Supreme Court. Petitioner further asks this court for a writ ordering Glanville to produce immediately, and certainly no later than prior to the start of cross-examination of Copeland, an unredacted transcript to defendants of the secret ex parte proceedings held on June 12, 2024. Yeah, they kind of need it. They're not only kind of, they should already have it. Because whatever was said in that ex parte meeting with all these people present, they need it because impeachment of Mr. Copeland, impeachment of the judge, impeachment of the prosecution. I mean, it's ridiculous that Judge Glanville believes himself to have that kind of power that he can just ignore constitutional rights. He just punts it forward because he knows it will take 5 to 10 years for the Court of Appeals to even consider this case, or even bring it up to the docket. Meanwhile, he can sit on his bench, may or may not have somebody under it from the prosecutions. No, I'm sorry. I'm furious because this is not even a kangaroo court. This is the kind of court that used to exist in former Eastern European countries, communist states, where this scam courts took a person, accused him, they had a defense attorney just for shows, and then the prosecution and the judge together decided the guilt. That is exactly what's going on in Judge Glanville's courtroom today. Let's go on. Petitioner also asks of this court that it enter any further writs or orders it deems appropriate given the actions of Glanville. In other words, Georgia Supreme Court punt this MFer out of the courtroom. Issues presented. Whether Glanville was correct in failing to follow the mandates of 25.3 by refusing to refer the motion for recusal to an unbiased judge for hearing following argument on June 12th, particularly after making findings in an order of June 14th that the motion was timely, the attached affidavits was legally sufficient, and that the affidavits contains assertions of fact support the allegation of bias and impartiality. Statement of facts, procedural history. In January of 2023, nearly 18 months ago, trial began in Fulton County Superior Court in State v. Diamante Kendrick et al. Yeah, This trial, you might think, but didn't it start end of November? No. Trial starts with jury selections. And jury selections took place or started in January of 2023. Jury selection took more than 10 months with trial before the selected jury beginning November 2023. Following the secret ex parte meeting proceeding on June 10th, petitioner filed and presented a motion to recuse and accompanying affidavit from Doug Weinstein to Glanville on June 12th. The motion to recuse was based on the impermissibly secrecy of the ex parte proceeding and the violations of the Judicial Code of Conduct that occurred during that secret proceeding. The motion was summarily denied in stanter with a formal order issued on June 14th. The ex parte proceeding. If you watched my other videos and streams, you already know this, but for you who are new here, welcome. You won't believe what might have taken place in this illegal ex parte proceeding. A central figure, perhaps the central figure in the state's case against Kendrick and the other defendants, is Mr. Kenneth Copeland, aka Woody. On Friday, June 7th, Copeland was sworn in. After being given a grant of immunity and being warned by Glanville that incarceration may be the result of refusing to testify, Copeland continued to plead the fifth. Copeland was held in contempt and ordered incarcerated by Glanville on that date. Glanville instructed Copeland and all parties that Copeland would be returned to court on Monday, June 10th, where Copeland would announce whether he was prepared to testify. Unknown to any members of defense counsel, an ex parte proceeding was held in Glanville's chambers on June 10th. Among the attendees were Glanville, ADA Love, ADA Hilton, investigators of the Fulton County District Attorney's Office, deputies, sworn witness Copeland, and Copeland's attorney, Miss Kayla Bumpus. No member of defense counsel were present at the ex parte proceeding, despite Copeland's invocation of his Fifth Amendment rights being at a critical phase at the trial. Neither Glanville nor any member of the court staff nor the Fulton County's DA's office made any members of defense counsel aware of the ex parte proceedings either before, during, or after the proceedings. One or more members of defense counsel were later made aware of the ex parte proceeding with sworn witness Copeland, though not from Glanville nor from the DA's office. You know what this tells me? This the DA's office and Judge Glanville has done before on numerous occasions. No idea how many, but the law and the statutes are so clear on this. The only way everybody involved stayed quiet and knew to stay quiet is because they have done it before. I would assume in this trial and many other trials in Fulton County Superior Court. If this Pandora's box is opened and defense counsels in Fulton County starts to wonder, well, I wonder if they did this in my trial, because that witness went from not wanting to testify to all of a sudden spill all the beans after this 1 hour, 2 hour break in the proceedings. We have no idea for how long this Buster clock has been going on. Probably for the entire... Judge Glanville took the bench in 2005, I believe, in Fulton County, and it's been there ever since. So there might be cases going back almost 20 years. Specifically, Weinstein learned that Brady material was disclosed in the ex parte proceeding and withheld from all defense counsel. Upon information and belief, the following events occurred at the ex parte proceeding with sworn witness Copeland in the chambers of Glanville. Upon information and belief, Copeland announced that he would invoke his Fifth Amendment right and not testify. Copeland stated that he would rather sit in jail for 2 years than testify. Glanville informed Copeland that Glanville could keep sworn witness Copeland incarcerated until additional defendants were tried, not just the 6 defendants currently on trial. Yeah, there is about 12 more awaiting trial. They are waiting for this trial to finish, and then their trials will begin. That's a serious threat. ADA Love or Hilton informed Copeland that there were over a dozen defendants left to try. Yeah, I should have just kept reading. Following the above coercive actions by Glanville, working in concert with one or more attorneys from the Fulton County DA's office, sworn witness Copeland stated that at the ex parte proceeding that he would testify. Glanville also presented sworn witness Copeland with a printout of the perjury statute and the false statement statute of the state of Georgia during the ex parte proceeding. Sworn witness Copeland stated to ADA Hilton that if called to testify, he would simply lie on the stand. Important Brady material that has yet to be provided to Kendrick or any of the defendants. In response to Copeland's statement that he would lie, ADA Hilton stated that she would not prosecute sworn witness Copeland if he were to lie on the stand. These folks are so desperate in getting a conviction, they gave Woody immunity to lie. They gave him permission to lie on the stand. Imagine how corrupt you have to be to tell a witness, no worries, if you want to lie on the stand, just lie, we won't prosecute you. I mean, how low is your how low can you go? It's so infuriatingly stupid. It's unconstitutional. I mean, I've never heard of this. A prosecutor actively telling a witness it's okay to lie on the stand under oath. Sworn witness Copeland also stated to A.D. Hilton that he would testify that he killed Donovan Thomas Jr. Important Brady material that has yet to be provided to Kendrick. Yeah. In response to Copeland stating to A.D. Hilton that he would testify that he was the perpetrator in Donovan Thomas' murder, Hilton told Copeland that she would prosecute him for perjury if he testified that he killed Thomas. Important Brady material. Yeah, first she gave him carte blanche to lie. Copeland said, well, then I will testify I did it. No, then we would prosecute you. Meaning the prosecution gave Copeland permission to lie as long as it benefited the prosecution. This tells me that none of there's not an attorney in the district attorney's office that should be able to keep their bar card. This is so beyond any rules of ethics. Far beyond. In my opinion, the Georgia State Bar should hold an emergency meeting and give just everybody in the Georgia District Attorney's Office should be called to the Georgia State Bar and in 5 minutes or less explain why they should keep their bar card. Will that happen? No. But you can always wish. These troubling facts not only implicate Glanville in an impermissible effort to join forces with the state to coerce Copeland to testify, but also demonstrate an illicit effort to repress Brady material that should be provided to Kendrick. Attorney Kayla Bumpus, by and through a counsel, filed a motion to quash order to show cause and motion to recuse, attached as Exhibit D, on Friday, June 14th, which substantially supports the Weinstein affidavit. As a participant in the ex parte proceeding, Bumpus' first-hand account of the misconduct is credible. It is. And she says, there is no privilege. Nobody said it was a secret. Nobody said you should never tell anyone. Nobody said anything. I think that is the pride or the misuse and misconduct is so ingrained in Judge Glanville and the prosecution's office that they assumed everybody involved would just keep quiet without an order. And why didn't they submit an order to stay silent? Because a submitted order can be appealed. And then everybody would know. So they assumed Kayla Bumpus would stay quiet. She allegedly didn't. Good for you, Bumpus. The facts Attorney Bumpus asserts are as follows. As on Monday, June 10th, at approximately this time, 8:30 a.m., Mr. Copeland and his lawyer, Attorney Kayla Bumpus, were escorted to the court's chambers and conducted an ex parte meeting regarding whether Mr. Copeland would testify. Exhibit D. Those present for the substantive portion of this ex parte proceeding were Glanville, Copeland, Attorney Bumpus, lawyers Love and Hilton, members of the court's security staff, and deputies, 2 investigators from the Fulton County District Attorney's Office, and the court reporter. In chambers, Glanville asked Copeland whether he was prepared to testify. He planned to resort his Fifth Amendment privilege. And so she reaffirms what actually happened. And then this motion goes on what happened in court about the time of this secret ex parte proceeding. They came to court in time because they expected to start quite early. They waited and waited. And then all of a sudden, between 11 and 11:30 a.m., we are back. They tried to ask Glanville about the reasons for the delay. And Glanville just, And then it all came out, and crashing down on Glanville. And then Glanville made all these efforts to keep everything quiet until he couldn't anymore. He put Mr. Steele in jail, more or less. That was quashed immediately because Judge Glanville proved that he doesn't understand law. He cannot tell the difference. He doesn't know the difference between civil contempt and criminal contempt. Criminal contempt, you get punished. Civil contempt, you are held in custody until you do as the court orders you. So Judge Glanville gave criminal contempt order on Attorney Steele, but he still wanted the information. And this is a judge who's all about protecting himself now. He is in self-defense mode. And he doesn't care because he hopes that he can punt this until after this trial. And then he can blame the appeals court. Oh, I think they did wrong and blah, 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 blah. Because sadly, he was re-elected unopposed in May of this year. So he's in the beginning of his new term as corrupt chief judge in Fulton County. And it's... Yeah, and it goes through all that happened. And we already went through this in my other videos and streams on this. So I don't have the time. And they have all the citations, they have all the statutes, they have all the rules of ethics, they have everything needed for the Georgia Supreme Court to step in and say, "You're all effed up here. Judge Glanville, produce everything that was in the entire transcript. You recuse yourself. Report yourself to the state bar. ADA Love, same to you. Report to the state bar. ADA Hilton, or DDA, whatever it is. Report to the state bar. You, the other minor assistant district attorneys, try to find another line of work. Unless you want to testify against Hilton, Love, and Glanville. This should be the end. I mean, this in itself should mean the end of the Young Thug RICO trial, because the amount of misconduct in this trial is so staggeringly high. There is no way for any court to hold a new set of proceedings, because there's too much crap. This is not polishing a turd anymore. This is trying to gold leaf the runs. It just can't happen. And we've seen the weakness of this state's case throughout this trial. They really don't have evidence. They have gossip they try to present as evidence, and it is appalling. Thankfully, the defendants have extremely good defense attorneys. And it is my hope that at least the Georgia Supreme Court puts a stay until everything about the recusals are in order. So that was the extraordinary motion, the writ of mandamus to the Georgia Supreme Court to yeet the judge. And hopefully they will. Thank you for listening. Watch my other content. Have a pleasant day. Hug your family. Unless your family is crap, then screw them and give your love to the people who deserve it. I will see you later. Bye-bye.